The crime's prosecuted on occasion, correct? It's just the fact pattern here that is unusual, is that?
Yes, Your Honor.
And I guess on the fact pattern here, how are you going to have evidence that goes one way or the other? I mean, the fact that no one's been prosecuted who allegedly stole a document from the next person at the city council meetings. So I'm just curious what you think, how this is going to proceed. I mean, you look at the video, which I have, and you could come to one conclusion about this.
It's in that sense, it's similar to other statutes like child endangerment, for example, where you do have a serious crime, but you could have somebody like, I let my 13-year-old kid drive around the neighborhood on a bicycle, right? And if somebody is arresting me under the child endangerment statute, then it raises red flags.
But if the conclusion is that someone intentionally the evidence suggests probable cause that someone intentionally stole a document, that's a government document, and did it with a motive because concerns have been raised about her role in getting the signatures on the petition the day before. So she had motive, and you have the video, and we know that stealing a government document is, in fact, a crime that's prosecuted. I guess
Yes, Your Honor. Two things for that. Number one is that the statute is a general intent statute. So you don't need to be looking at her motives. Why would she take a piece of paper from one side of the dais and put it on the other side of the dais? But even if...
keep going. Sorry.
But no, you're right, Your Honor. Even if you were to say that this is a crime, on the one hand, you have a probable cause for a serious crime, and on the other hand, you have evidence of retaliatory motive that courts should be allowed to at least look at it. The problem with the Fifth Circuit's rule...
Yeah. I guess the concern I have here is the crime is the offense is a serious offense, the offense itself. The question is really whether the facts of this case meet it. But if you concluded that it met it, other people would be prosecuted for that too. The fact that there hasn't been someone else prosecuted just shows that, I suppose, no one else in these circumstances has been accused of that, or they haven't found anyone. But if you intentionally stole a government document at a government proceeding,
Justice Kavanagh,
that's not nothing.
We disagree with that characterization. Our position...
I understand that.
Yes.
But in terms of concluding that it's retaliatory, I think you have to show some evidence that she was singled out under Nieves, singled out. I mean, Nieves is very specific about saying you need to identify similarly situated individuals not engaged in the same sort of protected speech, had not been arrested.
And under the Seventh Circuit's rule, we would be able to point to the mayor, and he would be a similarly situated individual. And also under the Seventh Circuit rule, we would be able to point to the fact that two police officers independently looked into Ms. Gonzalez and decided there was nothing there, that a prosecutor looked into Ms. Gonzalez and decided not to pursue charges. And it also gets to this idea of how many crimes we have on the books today. It would be one thing if you had 70 crimes. It's another thing when you have 70 million crimes, and they are written in a broad manner.
Right, but stealing something intentionally, if that's what happened, that's...
there is probable cause to say that she concealed the government record because she took a piece of paper from one side of the dais and moved it to another side of the dais. As Judge Oldham explains in his dissent, this kind of a crime is akin to letting my kid ride a bicycle around the neighborhood, but being charged under or being arrested for child endangerment.